Welcome to today's segment of You and the Law. At the last segment, we did explain what contract is, the types of contracts, and elements of a valid contract. We will continue that conversation today, or that discussion today, by examining vitiating elements of a contract. Yes, granted that a contract has been created between two parties, there are situations or circumstances under which a contract that has been validly entered into can be brought to an end. Contract that has been created between Mr. A and Mr. B can be brought to an end in law if some elements are established or some of these factors arises, including fraud, undue influence, duress, misrepresentation. Let me start with fraud, where a party in entering into a contract defrauds the other or makes fraudulent misrepresentation that was not known at the time of creation of the contract. That contract can be brought to an end. The party that is the victim of that fraud has the right in law to end and terminate that contract. Again, where a party is made to sign to a contract under duress, that is by force, that party has the right to seek redress, to terminate that contract, to rescind that contract, and resile from the performance of his obligations under that contract. Therefore, duress is a vitiating element. That is why a contract has to be made freely, by free will, by both parties. Undue influence is a situation where someone is not necessarily made to do something by force, but some influence is unduly exerted on that person, possibly due to the position of the person that is exerting the influence. Again, I want to also state that yes, a contract has been created, but it is possible that while parties have committed themselves to the performance of a contract, what we call frustration can occur. Frustration basically is a situation in law whereby parties are discharged from their obligations under a contract, or where the performance of the terms of the contract becomes impossible as a result of circumstances that are beyond the control of both parties. When can this occur? Frustration, for example, can occur where the subject, the lease of the contract, no longer exists. That is where what parties have agreed to do, and that subject of the contract is no longer in existence. That contract is deemed to be frustrated. Frustration can also occur by act of God. For example, earthquake, other natural disasters, and so on. Where that has the effect on the performance of the contract, both parties are discharged from the obligations under the contract. Government policies can also frustrate a contract. For example, where the government comes up with a policy or a law is passed that has influence and has direct effect on the terms of the contract. Illegality is another reason why a contract may not be able to be enforced, why it may not be possible to enforce the terms of a contract. In a way, a party agreed to do something that the law has forbidden, such a contract cannot be enforced. Where a contract is also contrary to public policy, such contract can also not be enforced.